Hi everyone, and welcome to today's webinar on developing your funding application. For those who don't know me, my name is Roslyn Munro and I'm in the Director's role at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners on the land in which we're holding this webinar today in Brisbane. They are the Turrbal and Jagera people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. So as you're aware, hopefully you're aware that you've joined a webinar that is about developing your funding application, which is about particularly the procurement process that is currently on foot in Queensland for legal assistance services. The PowerPoint will be available on our website after this webinar. You can also ask questions at this webinar. You can press the button that looks like a hand on your screen and we'll see a hand go up and we can unmute you so you can ask the question via the microphone, or you can type your question into the question box on the control panel and we will read your question out. So we'll probably hold off questions until the end of the presentation. But feel free to type them in as you go, and we'll make sure we cover things off by the time we get to the end of this webinar. So without any further ado, let's talk about today's topic. So just by way of background, this funding application process is about the Queensland Government allocating over $120 million of Queensland and Commonwealth funding for the delivery of legal assistance services in Queensland between 2020 and 2025 through an open tender or procurement process. As many of you are aware, the National Partnership Agreement for Legal Assistance Services expires in June 2020, and that new agreement is still being negotiated between the Commonwealth and state and territory governments. So the reason why I mention that is because there are a few transitional issues that come up in the procurement process that may end up being consistent or otherwise with the new agreements, because we're making sure that this money is moved out into the sector prior to the expiring of that agreement, but also in anticipation of a new agreement. So for those of you who have been on Q tenders, hopefully most of you, if you're intending to put an application in, there are a range of funding application documents you need to have in front of you. The application form, which goes without saying. There's a set of guidelines that JAG have also produced around how to apply for funding. There's an application resource guide that Community Legal Centres Queensland has produced, and I will be running through that guide today, which talks a little bit more in depth about what particular questions might mean when it comes to the legal needs research. And we've also developed an evidence and analysis of legal need, which will be an important document to help guide the telling of your story, which has an evidence base. And I'm joined by Janelle Reese here today, who developed that guide, and I'll bring Janelle in to talk about evidence in a little while when we get to that spot. So we'll run through the application form. The only other key date that you should really have on your radar is that the applications need to be in by 2 p.m. on the 4th of December. So you've still got a good month to work on your applications, but it's important that you plan out your application early in the piece so that you're not having to run down to the wire of that date. So there are a series of mandatory evaluation criteria which really are about providing a bit of a threshold about whether you are eligible for this funding or not. Those questions include whether you meet or comply with a quality standard. If you're a community legal centre, the National Accreditation Service scheme is a relevant certification. If you're not a community legal centre, then you might be compliant, say, with the Human Services Equality Framework, which is another form of accreditation. You do need to be currently providing free legal services to vulnerable and disadvantaged Queensland, not just thinking about it, or providing free court or tribunal support and advocacy services to vulnerable and disadvantaged Queenslanders. A couple of other things you need to provide is your audited financial statement from 2017-2018 and a financial statement from 2018-2019. Some of you may already have an audited statement for that particular year. You can submit that, but given that we are still in AGM season, there might be some organisations that don't have an audited statement. So when planning your approach, there's a few things that you should bear in mind. Bear in mind that the quantum of funding in Queensland is not significantly growing. Whilst the amount of money does look like a larger amount of money, a number of programs sitting outside the MPA, like Women's Safety Package, are being rolled into the new agreement. So that means the money does look a little larger, but we know already that those funds won't be repurposed for something else. So you need to bear in mind that some of what looks like new money is already kind of locked in to particular purposes. There is a small increase in the Commonwealth funding, and I think it's less than $400,000 per annum as an increase. So really the quantum is not growing. So if your approach is to ask for the total $120 million odds on you will not be getting that amount of money. Or if you are thinking about radically changing your ask, you need to be prepared for what you may or may not get in through this process. You also need to think about what your core services are, which is kind of being described as business as usual. What do we currently get funded to do with through CLSP? What are we seeking to continue to do over the next 5 years? That's your core funding. Your new funding would be something that you're not currently doing, but you're proposing to do as part of this application process, and you need to make a very strong case around why you need to add to this new. So when you're thinking about planning out your application, think about what is core, what is new, because you need to make sure that you're making a very good, strong case for new. And as we get further into the application form, I'll give you some examples of where you might need to emphasise the new over the core in order to make that case. So after the 2016 procurement process, there was a round of feedback from a range of different players in the last process, including the evaluation team and the department and the sector. So there's some guidelines that we're suggesting that you might want to take on board when you're thinking about your total application. The first thing is you need to focus on how you know the services work and how you will continue to monitor their impact. So it's really important that you make good connection between activity and impact. So the example here is that over 60% of our clients indicated they had their legal issues resolved, and there were specific comments about how working with a legal service and a counselling service under one roof helped to decrease their stress. So it's not, a deep response is not, we attend network meetings so we can collaborate with other service providers, full stop. There's got to be a reason why you might do that and that there are particular impacts. So being able to be clear about how you measure your services and their impacts is important. And I guess over the last 3 years since the last procurement process, we've been doing some work with the sector about how to go about doing that. That's not the point of this webinar today, but to really bear in mind some of the thinking around impact that's been happening more recently. There is still a repetitive element to the questions, as some of you might have experienced in 2016. So using how you're going to plan out your responses across the application to either to capitalise on the repetition or reduce the repetition. So when you're thinking about applying core services, select the strongest examples for the concepts rather than feeling like you have to provide an example for every single thing of your core service and of that concept. So if the concept is collaboration and it's a core service, then you might be picking one particular program area that you think really illustrates strength in collaboration. But if you're applying for new or additional funding, make sure you provide an example for every instance where you're applying for new and additional funding, so that you're making a strong case that resources need to be allocated for that purpose that haven't been otherwise in the past. Always bear in mind the weighting of the questions in the guidelines that JAG have put out. Always bear in mind with each question about what evidence you are drawing upon to demonstrate need, performance, impact, and why you're selecting particular service delivery models. So, if you're covering a large geographic area, your service model might be telephone advice. Being really clear about why that particular service model meets the evidence of that large geographical area. Again, we've done some work around impact measurement. If you're curious about that, we have done an impact measurement toolkit, which is on the web, that may provide you with some guidance about how you might think about how you achieve particular intermediate outcomes through that theory of change on which that toolkit is based. So, for example, some of the intermediate outcomes that you might thread through your application is that the client has more knowledge of their rights and responsibilities, or there's an increased number of clients accessing referral services, or courts have improved speed and efficacy, efficiency in processing cases. So the first set of questions go to the description of the services. This is fairly straightforward. The geographic regions, you've got a free text box. For those that fondly remember the 2016 process, you had some tick boxes of regions. It's clear that the sector has made a lot of changes, and you're working across regions as well as perhaps statewide, and so a free text box will allow you in a more narrative way be able to talk about which regions. If you weren't wondering what those regions are, go to the evidence guide. All of the regions are set out there. They are legal aid office websites on which a whole range of regional planning is done. They're not electoral boundaries, they're not local government areas, they're a cluster of SA3s that link into a local legal aid office. So yes, there's no guarantees that population sizes are all the same and all of those sorts of things you might expect in other statistical kind of narratives. So the next question is about location of services. That's pretty straightforward, where you've got offices, where you have outreach locations. And finally, the client groups that you'll focus on. That's a tick box, which allows you to identify which priority client groups you're identifying under what have been the list of the National Partnership Agreement priority client groups. There are 2 additional client groups of LGBTI people and refugees and migrants. Those are 2 additional client groups that the state government has identified as priority groups, which we think is a good thing. And to also bear in mind that in the last MPA there were some requirements for particularly complex and ongoing work to ensure that at least 90% of those services were directed to financially disadvantaged people. So something to bear in mind as you're thinking about service delivery and who you're directing those services to. So the brief overview of your organisation is a question that allows you to put your organisation and your ask into context. So whilst it's not a weighted question, it is, it's compulsory information and taken into account when the application is read as a whole. But it does allow you to be able to put your best forward in terms of the credentialising of why you should be funded to provide services in this area in terms of your history, your expertise, your ability to use resources wisely, and all of those things that you might expect at the beginning of a grant application. So the first meaty question in terms of some of the legal needs research is the nature and types of services and why they are delivered to particular client groups and geographic areas. So this is really going to be the question where you're going to set out what services you're going to provide and tease them out in a way that is clear about this is why we're providing these services to this particular group. You're going to be drawing heavily on the evidence base here to make sure that you have got good justification for providing particular services in particular areas, and those services are of a particular type, and that they take into account the relationships and the partnerships that you have in order for you to be able to deliver those services. This question does have a need for you to really focus on the evidence. So I might just pause here and throw to Janelle to maybe talk a bit about the evidence guide if you haven't had a chance to look at it by now.
All right, so the evidence guide was developed in part for this procurement process to give you a set of baseline information and data to support your application. It's underpinned by the legal needs analysis from the Law and Justice Foundation in New South Wales, and we went to a wide variety of sources to get the evidence and data that went into the evidence guide. So the Queensland Government Statistician's Office, census data, government documents and reports, academic research was all undertaken to put together what is the evidence guide. So it's divided by priority groups at the start, and since the Queensland Government has now announced 2 extra priority groups, we have also put together an addendum for the LGBTIQ people and refugees and migrants. And then it goes into the regional areas, which Ros has already stated, are divided up by clusters of SA3s rather than electoral boundaries or local government areas. So the purpose of the guide is really to give you a starting point for your application, to support your application with a whole host of evidence, but I highly encourage you to contextualise that research using your own knowledge, because the evidence guide is based on the data that we were able to source, and you know your regions and your communities the best. So take that information and contextualise it to your own area.
So hopefully too, the evidence guide allows you to do a little bit of cutting and pasting. If you're really strapped for time, hopefully you can find those external pieces of evidence that Janelle has talked about, just being able to lift them straight out of the guide, that's perfectly reasonable to do. And you might be then supplementing with some of your own service data that you think is good evidence as well. So I think just covering off again that use the evidence. It's quantitative and it's qualitative, so don't be afraid to draw on your own experience of your communities to be able to speak authoritatively. Particular specialist areas are going to have your own body of evidence that you draw upon all of the time that's going to be relevant here. So again, just highlighting sources of evidence is the evidence guide that we've just talked about. I mean, there are other places you can go for evidence: court and tribunal data, local government, class data, community trends. So check out the evidence guide first and foremost, because hopefully we've shortcutted some of those sources in that guide. But again, I think it probably does depend on the nature of the services in your application as to what is going to be the best evidence. So question 6 is describe how the services focus on and are accessible to people facing vulnerability and disadvantage. So there's a couple of components to question 6. First of all, you'll be thinking about how do you target legal need in your community. So thinking about what are the barriers experienced by client groups, what are the strategies that might help you to target particular services to particular client groups, and show that the service delivery models actually reduce those barriers or kind of address the barriers. So thinking about that example of, regional Queensland, where, face-to-face communication may be challenged. Is it appropriate to provide services via telephone or Skype to overcome barriers of distance? That might be appropriate for some priority groups, but maybe not for others, and therefore an outreach model is much more appropriate where face-to-face is critical. So the sorts of examples of targeting strategies that you might want to think about is how you use client eligibility criteria to determine who gets a service, when and how. Whether visibility in the community is really important. So you need to be the go-to organisation in a particular location. So outreach or shop fronts or service models that increase visibility in the community, or not? Or do you need to be not visible because they're highly sensitive safety issues at play? Intake processes, of course, and triaging process assist with being able to work out who is eligible for a service, as well as who should be prioritised when there is overwhelming need. How do you use referrals to and from legal and other community-based services or government services? And how you use collaboration or partnership with legal agencies. So, for example, do you have a partnership with a local domestic violence service that they are identifying people that need priority legal services for domestic violence application? That is a way of how a community agency might be triaging for you or assisting the triage process to identify those most in need when they mightn't be coming to your door. So the next question is also got a few components to it, and it is about describing how the services are appropriate, proportionate, client-focused and tailored to people's legal needs and capabilities. We think there's 3 key questions that you should be trying to address in this particular question. The first is, how does the priority group understand they have a legal problem? How does the priority group respond to or seek help for legal problems? And how does your service delivery cater to those particular capability challenges? So I might just unpack those questions a little bit more. So, for example, you might have a priority group that may not be able to identify that they've got a legal problem. They only identify they have a legal problem when they are served with the summons, or they have got a court date that they've put off for as long as they possibly could. So that if those clients are not addressing their legal problem, or understand they've got a legal problem and then delaying their getting a response to their legal problem, they might be looking for a service that is literally at the door of the court, that sort of just in time we need to have a service. If you have clients, priority groups that are saying we're really proactive about identifying our legal problems, legal information might be an appropriate way of catering to those particular capabilities. So the types of strategies are many and varied, making sure that you link your strategy to the capability. So as we said, it could be legal information and education and self-help, which are fairly low levels of intervention, through to really integrated service delivery, case management approaches, having quite specific tailoring to specific problems. So, we do an outreach at the local youth service because young people will never walk through our door. So there is a whole range, making sure that you connect whatever your service delivery model is with whatever is your understanding about how those priority clients identify legal problems and then attempt to address them. Question 8 is describe how the services are collaborative with government services and other services to provide joined up services to address people's legal and other problems. So this question really focuses on how the service system fits together. So if you're in the shoes of government thinking about what to fund, you want to make sure that the system that you are funding is as seamless as possible, given the constraints to resources. But if an applicant can make it relatively easy for government to see how you are dovetailing in with other legal services and other community providers and are working to maximise that integration, that's the sort of things you should be talking about in this question. Again, myriad of ways to talk about collaboration, everything from quite sophisticated partnerships through to networks, through to co-location, joint planning, multidisciplinary practice, short-term project work on a particular area of need, making sure that you always connect whatever your mechanism is for collaboration with why is this an appropriate way of using collaboration given the services you are providing. Question 9, describe how the service identifies and resolves legal problems in a timely manner. Timely in this case has a few different interpretations. So timely resolution of legal problems can mean early intervention and prevention, things like education and information. Client-centred timeliness, so the example of the person that will only seek out assistance for their legal problems when they're at the door of the court. The client-centred timeliness would be to provide a service at the door of the court. Even though it doesn't have that feeling of early intervention and prevention, it's still timely from the perspective of the client of they are seeking help at that particular time and there is a service available. So systemic prevention strategies, so any policy and law reform work that you're doing and how that assists with ensuring that more people are not experiencing similar types of legal problems, and anything that you think contributes to the efficiencies of courts and tribunals. So we know that time lags in court and tribunal processes mean that people are not having their legal problems resolved in a timely way, in a client-centred way. So anything that you might do to contribute to those processes working more efficiently and effectively is also timely. Question 10, describe how the services empower people to understand and assert their legal rights and responsibilities and to address or prevent legal problems. So this question is very squarely in that CLE type of response, sort of how do you use information to ensure that your target client groups are aware of their legal rights and options? How do you make sure that information is appropriate for that client group? And how will the information sort of build the capacity of that client group to maybe identify and resolve future legal problems? So some examples there are that you might be working with a priority client group where English is not their first language. How do you make sure that they've got access to appropriate information given the difficulties with reading English, for example? So, and before I move on to the compulsory procurement questions, just another plug for our application resource. We have got examples for every question in that application resource. They're not the perfect response. They don't get 10 out of 10. We don't know what gets 10 out of 10 in this procurement process. But hopefully those examples will give you a sense of how to apply some of the concepts that you're being asked about in the questions. We've also tried to thread through how you might talk about impact through your responses so that you're able to use your own data and methods of monitoring services in a way that can be woven into your responses. So there are a few compulsory Queensland Government procurement questions, and the background to this is the Queensland Government have developed some policy settings within their whole of government procurement strategies to ensure that certain social policy outcomes can be achieved. So that's why if you're involved in the 2016 process, these are new questions. I think these are questions that all community legal centres should be able to answer pretty easily and should not have to spend too much time sort of labouring them. Look at the examples we've provided, and I think you should be able to come up with relatively quick and succinct responses to these. So the local benefits question is about probably more specifically directed at larger infrastructure type projects, so bear that in mind. But how do you actually provide local jobs? So if you've got people that live in your local area and you're employing them on fair wages and conditions and award conditions and making sure that they are employed on good terms, then you can tick the local benefits box. You might be using local businesses or contractors to supply things to you, like your stationery, anything you might be doing that requires you to bring in an external contractor. Opportunities for apprentices and trainees, probably not so relevant to this sector, but it might be that you've got student interns from a local university that you could talk about there. And other case-by-case benefits, for example, if you've got a policy of engaging as a priority with Aboriginal and Torres Strait Islander businesses, this is the place where you might mention those types of things. The second compulsory question is about implementation of workplace policies to end domestic and family violence. So you can set out what you're already doing in this space and what you might intend to do during the funding period. So there are unpaid domestic violence leave conditions under the SCADS award, but you may have or are thinking about doing something that extends that. So things like having a domestic violence policy for staff, or giving some paid domestic violence leave on top of what is covered in the award. The other thing you might want to talk about is your flexible work conditions and how you might accommodate staff that are having those experiences. So again, I don't think it is a difficult thing to cover off, and you can speak to the things that you're intending to do as well as what you're already doing. When it comes to the deliverables, which are the sorts of figures that we have been working with if you've already been funded before in this area around your outputs, it's always good to be realistic about those numbers, about what you can actually achieve for the dollars in terms of those outputs. Think about staff leave and staff turnover and the sorts of things that invariably happen in organisations that will reflect on targets, reflect on what you've said, what you've been able to do previously. And if you're not asking for extra money, perhaps you're not asking to provide more deliverables. We do know with the MPA coming to an end and the new instrument not being fully developed is that maybe some of the outputs might change. There's been a big discussion in the sector about other representation. So if there are major changes to the data standards manual and those particular outputs, then the department have assured us that successful applicants will be able to renegotiate the deliverables. Last time in 2016, if you didn't get the full funding amount that you asked for, you were still able to renegotiate those targets. So the department has a good track history here, and there isn't anything that I would think at this stage that says that you should be concerned about that, but at this application point, trying to be as realistic as you can, bearing in mind that the MPA did have a 90% of representation services must be delivered to people experiencing financial disadvantage, and we could expect that to be the case moving forward in the new instrument or something similar. The amount of funding you are seeking, this is again thinking about core, what you need, what amount of money you need to continue to provide the same level of services. Additional core, which is core with more, which is doing more of the same, or so not thinking about introducing a new program, but perhaps increasing your service delivery on the same type of work by 20%, 30%. Then there are the new services or programs, that a service that's not been previously funded from this source. So for some organisations, this may get a little tricky, and we're happy to field questions individually on those questions. But if you are not funded through CLSP to do this work currently, that you've either got another source of funding doing providing the work, or you're self-funding, then that is new for this particular funding program. But if you have specific questions about that, we can perhaps take those offline and work that through. Also consider changes that might impact funding levels in Queensland. There's an introduction of portable long service leave scheme, but also bear in mind, if you're at the workshop session that Carly ran, government are not expecting large changes to funding arrangements off the back of the portable long service leave, because there's an assumption that organisations have been setting aside staff entitlements for long service leave in accordance with their obligations. The final question, value for money. This question was there in 2016, and it's being able to make the case that the level of funding sought is appropriate to the nature or context of the services. So clearly an outreach service that is dropping into 5 regional centres is a model that requires considerable investment, but it's highly appropriate. So it's not about being the cheapest service, it's being able to justify why there's a particular ask and why that is necessary in the circumstances given your geographic and priority group situation. It's also an opportunity to talk about how you value add to the funding that you get, and we know CLCs are very good at doing that in terms of using volunteer support, pro bono. You might have some shared operational costs through co-locations. You might be pursuing diversification with funding streams that ultimately government benefits from. Finally, you need to be able to make a couple of declarations. The first one is that you can declare that you're an ethical supplier. Again, this goes back a little bit to some of the things that you were considering with local benefits. Ethical supplier meaning that you're a good employer, you're not employing people on short-term contracts when in reality they should be employed on long-term contracts or on more permanent basis, that you're using award conditions, that you're treating people well that you employ, that you're using modern award wages and conditions, you're making appropriate superannuation payments, and not treating everyone as independent contractors. Again, you just need to tick the box, and those are the sorts of things you might turn your mind to when you're ticking that box. So in terms of our ongoing support, we've got the application resource, which I've walked you through today, the evidence and analysis of legal need, which Janelle talked about, and hopefully is your first port of call for any evidence questions you have. And we're also happy to be phone a friend. We don't need to, we can't give you, we can't read drafts and tell you whether you've got given a gold star after reading your draft. But if you need a sounding board to try and clarify how you might respond to questions, we're very happy to be that sounding board. Okay, so I'm just going through some of the questions. Just to remind you, you can type them in the question box, or you can stick your hand up and we can unmute you and you can ask the question online. So, I'm going to read out the questions that have come through. We've got a question here about core and new services. We have a specific program that we have been running for 5 years, funded by donations and our own savings. If we're applying for NLAP funds for it, will be treated as core service or as a new service. Without sort of knowing too many details, it sounds like that is a new service. If it hasn't been funded by CLSP funds previously, that is a new service, even though it may not be new to your organisation. So there's a second question. It's about funding programs being brought into the CLSP, so the Women's Safety Package and the Coronial Assistance Legal Service. To help us understand the money dropping in and those services programs have fallen out, can you, as extensively as possible, list what's going on and coming out? Obviously, we have two reality tests asked in light of a mere 370,000 additional funding per annum. All right, some of this NLAP stuff is still to be worked out, and I think look, what we know is Women's Safety Package is coming into the NLAP. we know that anything that was funded in 2016 on top of the procurement process, like coronial services and LGBTI legal service, for example, they are now all in sort of the core funding of CLSP. So if you are funded for any of those sorts of activities, you would be making an application for those services in this particular application. If you are, running health justice partnerships or DV units under the Women's Safety Package, then you need to be covering that off in this application as well. I know there's some particular circumstances of particular centres very happy to take conversations offline about that if you're worried about a particular aspect. It might be that we need to liaise a bit more with the department to get clarity. So, yes, happy to maybe talk about that off length if you think offline at length if you feel like that's not going to be of assistance to you and we need to dig a bit deeper. Can we include the 2018-2019 annual report instead or additional to the 2017-2018 annual report is the next question. This came up in 2016 because we know that the annual report, we wanted to be clear that it is the annual report that everyone's most likely to have as opposed to the one that they might be in the process of getting signed off at their AGM. So I would be following the requirement of the application form first and foremost, but that might be a question that you can direct to Q tenders to ask, because I'm not in a position to sort of say, yes, go ahead, put in your latest annual report. But you can submit questions through Q tenders, and so that might be a good one to submit there. So the next question, I may have misheard at the CLCQ Leadership Forum, but I could have sworn that I heard that question 4, use of local workforces, was non-weighted, but it's weighted at 10% in the application. I can see other non-weighted questions, but I thought that one as well. The local benefits question is weighted at 10%. It is one of the only compulsory Queensland Government procurement questions that had to be weighted, and they had to give it 10% because apparently that is what is required across government on that question. So it does, I think it's 10% that you shouldn't sweat too much over though. I think knowing community legal centres, I think you can very much tick that box and not have to spend too much time on that one. So have the geographic regions changed since the last round is the next question. The answer to that is no, they have not. They are the same as 2016. So there are no more questions coming through at this stage, but we still have time if you still have a burning question. And again, making the offer to people that if you want to contact me, Janelle, Carly or Penny at our office, we're all across the application and the application resource, and we can be a sounding board for your questions, or if we can't answer your question, we will endeavour to try and get an answer. Don't forget about the ability to submit questions to Q tender. I think that the annual report question is a good Q tender question to ask. Okay, well, very best of luck to everyone who's making an application in this process. I know it can be really stressful and it's the last thing you feel like doing before you head off for Christmas. But I think, we're here to be used as a resource. Hopefully you find the resources helpful, and feel free to reach out if you need to. Thanks, everyone.
Another question came through.
No, I was just thank you.
Oh,
I'm not sure if I got to that. I think that was the last